Donald Trump doing what he does best, trying to delay justice by claiming, wait for it, presidential immunity yet again. Today, Trump's legal team filing a motion to delay his New York criminal hush money trial, which is currently set to begin March 25th, just 2 weeks away. Trump argues the trial should wait for the United States Supreme Court to weigh in on his presidential immunity claim. Those arguments are scheduled for April 25th. Trump's legal team writing, quote, "The court must preclude the people from offering evidence at trial of President Trump's official acts as the commander-in-chief." Trump claiming that even though Stormy Daniels was paid off in the fall of 2016, Trump didn't reimburse his then personal fixer and attorney Michael Cohen until 2017 when he was president. And thus, all of those actions are going to fall under the category of, quote, official acts. Trump's attorneys also arguing that Trump made statements about it as president and on official premises, referencing this infamous moment aboard Air Force One in 2018.
President, did you know about the $130,000 payment to Stormy Daniels? Then why did Michael Cohen make this if there was no truth or allegation?
Well, you have to ask Michael Cohen. Michael is my attorney, and you'll have to ask Michael.
His team adding, quote, "President Trump respectfully submits that an adjournment of the trial is appropriate to await further guidance from the Supreme Court." Trump has other legal problems of his own making waves today as well. Trump posting a $91 million bond in the civil defamation case of E. Jean Carroll as he tries to appeal that ruling. And despite that legal trouble and hefty payments, Trump is continuing to make statements that could land him back in court.
91 million on a fake story, totally made up story. False accusations made about me by a woman that I knew nothing about, didn't know, never heard of.
Miss Bergdorf Goodman, a person I never met. I have no idea who she is. I was given a false accusation and had to post a $91 million bond on a false accusation.
E. Jean Carroll's lawyer saying they could possibly sue again, stating, quote, "We continue to monitor every statement that Donald Trump makes about our client. And in the interest of full disclosure, I am friends with E. Jean Carroll." Joining me now is Renato Mariotti, former federal prosecutor for the Northern District of Illinois, and Christy Greenberg, former criminal division chief for the Southern District of New York. My thanks to both of you for getting us started this evening. Christy, I'd like to start with you. I want your reaction to the filing, specifically, let's look at the one that's in the New York case. Trump's attempts to delay, to adjourn this trial from beginning. You know, before the show started, I looked at really carefully the arguments that he's raising and put aside whether or not that conduct, as alleged, Christy, actually falls within the official kind of parameters or the perimeters of his official conduct. I had a concern about the fact that Trump is now citing to the Anderson case, which is that recent decision from Colorado, and also citing to the fact that SCOTUS decided to take up that presidential immunity defense in the first place. Do you think that actually gives Judge Juan Merchan some cause for pause now?
Well, those cases are interesting that he mentioned, but what's even more interesting is the case that they didn't mention, which was the case that was before Judge Hellerstein in this very matter, where Trump's lawyers sought to remove this case to federal court. And this very issue was put before Judge Hellerstein, and Judge Hellerstein said Trump is not immune from the people of New York's prosecution in New York Supreme Court. This argument of immunity is not a colorable defense. And he specifically went through these same duties that they are trying to, put forth now, and said these are not presidential duties. Hiring and making payments to your personal attorney to handle personal affairs, not a presidential duty. Reimbursing Cohen for advancing the hush money, not a presidential duty. That is law of the case, and they had the opportunity to appeal that to the Second Circuit. They did not do so. They had the opportunity even to bring it up in a motion to dismiss. They didn't do so. They didn't even bring it up in the time frame that they were supposed to for a motion in limine, which is just trying to exclude certain evidence from trial. This has not only been there, done that, it's already been ruled on. in the federal court in this same case, but it's also untimely. So yes, I understand that there are matters going on before SCOTUS, but they have already been adjudicated in this case, just as they were, by the way, with E. Jean Carroll. E. Jean Carroll in that trial, they also did not make the argument, and therefore the district court in that case said, hey, you didn't make it in a timely way in the first 3 years of the case. You don't get to make it now. So just as it was waived there, I assume it will be waived here, and the trial will proceed.
Yeah, and Renata, to Christie's point, Trump actually did appeal that decision from Hellerstein, but then he voluntarily dismissed that appeal, thereby actually not having the Second Circuit make a decision. But Renato, does it make a difference, though, that that decision was done by a judge to basically say you've argued for immunity, you don't get it, Trump, but the fact that the Supreme Court is actually going to be deciding it, does that end up actually maybe overruling in any way what a prior judge has already decided?
I don't think so. So what the Supreme Court is deciding is to what extent there is presidential immunity. That is sort of a standalone question. The issue here, and I agree 100% with what Christie just said, is whether or not there's collateral estoppel, because there was a finding by a judge that he had waived the absolute immunity argument, and then he didn't appeal that. Ultimately, he withdrew his appeal. So I think that issue in this particular case is decided. Now, could that impact the January 6th case or a different case? Perhaps. But it doesn't impact this case because ultimately he had the opportunity to make that argument. He did not make that argument. He waived it. And then ultimately he could have appealed. He ultimately withdrew that appeal, didn't go forward. And that, I think, disposes of that issue here. And that's obviously why he recognizes that's an issue. That's why he's trying to save it here at the last minute. I also agree with Christie, too little, too late.
Yeah, you know, Christie, within this motion, there's also some inconsistent positions that are taken by Trump that I think somebody like Judge Merchanter is going to pick up on. For example, he's trying to say that certain conduct, like his tweets that he did, that are at issue in this case, tweets that dealt with Michael Cohen and others, that those actually were in his official capacity. That's what Trump's asserting in this particular motion to adjourn the trial. But on previous occasions, Trump took an inconsistent position where he said, actually, those are personal capacity tweets that are being made, so you cannot actually use them against him. Does that require then some type of hearing by Judge Merchan to decide this in terms of whether he wants to adjourn the trial, or is that just something that can be dealt with as the trial actually commences?
I think the judge will look to deal with it before the trial starts. I think, you know, yes, they take positions whenever they think it is useful to them, and they don't always have to be consistent. It's certainly the case that these tweets that he was making, I mean, those are, you know, statements of the defendant in the criminal case. And again, they're dealing with personal matters about his personal lawyer. So, you know, I do expect that the judge will have a ruling on this, because really what they're trying to do is they're trying to take their immunity defense, which again, they've already waived. It's too late and it's already been dealt with. And they're trying to shoehorn it into a different issue, which is what kind of evidence can be admissible in the trial. And once you've said as a matter of law that they can't make the immunity defense, I don't then see how the judge is going to keep out certain evidence that on that same basis. So again, I think there is a tortured argument from the Trump team to try and get at a minimum some evidence thrown out. But these are the defendant's own statements. These are Donald Trump's own statements. I don't think this immunity defense at this late hour is going to save him.
And Renato, another Hail Mary that Donald Trump is trying to do is he's trying to buy some more time in the Mar-a-Lago classified documents case. Not so egregious. He wants 10 more days, which is more time than the federal rules of criminal procedure allow. But to the gamesmanship that comes from Trump Legal in terms of his defense, they, as in the Trump legal team, is saying, well, you know, Judge Cannon, Trump needs more time because he's going to go to trial in New York on March 25th. But in the same breath and out of the same mouth, they're now saying, well, you know what, we want to adjourn that case. Renato, how much coordination or paying attention is going on between Judge Merchan in New York and Judge Cannon in Florida? I mean, I know special counsel has filed its opposition to that motion for more time in the classified documents case. Great
question. I mean, the judges are not monitoring each other's dockets, But you can be sure that the prosecutors in both cases are watching all of those other cases. Pretty extensive team working with District Attorney Bragg, for example. Obviously, the special counsel has a substantial team. They're going to put that in front of the judge. You can absolutely bet your bottom dollar that these positions are going to get thrown in front of the other judge, and it makes them look bad. I think one of the issues with trying to delay every case is that ultimately it just makes you look bad in front of all the judges. It's much easier to delay all but one or to try to push them in a certain order. But, candidly, they did not try to delay this one early enough or enough. I really think that the Trump team missed opportunities to delay in the Manhattan DA's case. Maybe they, at the time, were less worried about it, and now they realize that they put themselves in a position where they've got a trial coming up, and it's a more difficult case than they really gave it credit for.